Welcome everyone to another Friday afternoon edition of a question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin here in Ottawa. Our firm operates, as most of you probably know, throughout Ontario, Toronto, Ottawa, Vancouver, and now in Alberta as well. So I'm going to be here for the next 30 minutes or so. And I will be here to answer all of your questions about employment law, workplace issues, you name it, I'm here to answer it with respect to, severance pay, health and safety issues in the workplace related to maybe COVID vaccinations, constructive dismissals, medical issues, anything at all. If there's something that you've been wondering about, either on behalf of yourself or maybe a friend or a family member, now is the time. I'm here to answer those questions, so send them in. I'll be here for a little bit to answer all of your questions. As always, if I don't get to your question or you have a question that you want to ask privately, you can always contact us at employmentlawyer.ca. You can also email us at help@employmentlawyer.ca, and you can speak to us and reach us that way if you don't want to send your question in during the live session today. You can go to employmentlawyer.ca. All of our contact information is there. My contact information is there. Every other lawyer at our firm has their contact information there, so you can always contact us that way. And we can assist you from there. So I see we have not a question, but a comment that it is Friday the 13th. Indeed it is. So, if you're superstitious, you may have some additional questions today about employment law or any issues going on there. Other than that, I expect, even though it is Friday the 13th, we should have a smooth question and answer session today. So if you want to send in your questions, we can get to them. In the interim, while I'm waiting for questions to come in over the next little few minutes, there's a few things, as always, that I wanted to get to. Actually, you know what? We have some questions that are already coming in, so I will start to answer questions, and if I have time to get to a couple of the employment or workplace issues I had in mind, we'll get to them after. So I have Deborah Ann on Facebook, who's asking, can workplaces force you to get the vaccine? A very good question, and one that we're getting every single day, daily, from many people. This is the question that's on everybody's minds right now, and for good reason. As things progress with the pandemic, we're seeing a lot more talk about making vaccines mandatory in the workplace, in different industries. The federal government just came out today and confirmed that they will, in fact, be in a situation where they're going to make vaccines mandatory for federal employees, public service employees. And so it's on everybody's minds. It's what everybody wants to know. And so in terms of mandatory vaccines in the workplace, they cannot force you. So it's very important to know that an employer cannot force you to be vaccinated. That's a personal choice that you will make. Vaccines have been recommended, but it is a personal choice in terms of whether you choose to get vaccinated or not. They can't force you. What the employer can do, up until today, because the law may change moving forward, but as of today, they can implement a policy where you have to be vaccinated in order to be in the workplace. And so if you are in a situation where your employer has implemented a policy with respect to the workplace and that you have to be vaccinated in the workplace, there's a few different things you can do if you either can't or choose not to be vaccinated. And the first thing that you should do is you should open up a dialogue with your employer, ask the question of, why is this necessary? Or, why is it that they're asking you for your vaccination status, for example, because that is private information that you don't have to disclose unless you're comfortable with it. Now, in terms of opening that dialogue up, it's important to know that if one of the reasons for why you will not get vaccinated is because you have a medical condition that doesn't allow you to be vaccinated, then your employer has to make an accommodation for you because of medical reasons. That means your employer has to make an exception to the policy for you if you're somebody who medically, your doctor is telling you you can't get the COVID-19 vaccine. The other exemption that's recognized by law is for religious reasons. So if you're religious, if your religion does not allow you to get vaccinated and there are religious reasons for why you won't be getting vaccinated, again, that has to be accommodated by your employer, and there has to be a reasonable accommodation made. And those accommodations can range. Sometimes they will involve working remotely, working from home, social distancing, wearing a mask, which most people are probably doing anyway, but those are the situations in which there could be an accommodation. If you're not getting vaccinated as a personal choice, it's not for a medical reason, it's not for a religious reason, you simply do not want to get vaccinated for your own personal reasons, then the employer can put into place other measures. So in other words, if you're somebody who can work remotely, the employer may say, that's okay, you're going to work remotely, or they may put in other measures into place. What we're starting to see is if you are somebody who is refusing to get vaccinated for personal reasons, for your personal beliefs, we're starting to see some terminations for that. Now, every situation is different, but in general, it's really important to know that an employer cannot terminate you for cause if you decide not to get vaccinated. So in other words, if there is no law saying you have to get vaccinated and your employer terminates you because you refuse, you are still owed severance pay. And it will depend on the various circumstances in terms of how much you might be owed, your age, your length of service, and other factors. But if your employer does try to let you go for cause without providing you with any severance pay, that is a big problem. And either way, you need to contact an employment lawyer immediately, get in touch with us so that we can assess your case for you and let you know where you stand. But to go back to kind of the initial question, which was, can they force you? They cannot force you as long as it's not required by law. Now, to link to the federal employees that we were just talking about, it just came out that the federal government is going to have all public service employees have to have a mandated COVID-19 vaccine. In a situation like that, where it's mandated, there's going to be more situations that arise. Most of those settings are in a unionized setting where the unions are likely going to take up the issue on behalf of those unionized federal employees. But in essence, those are situations where there can be that mandatory vaccine in place in order to work for the federal government. And that's because they're actually going to change the law in order to enforce that. But as of right now, at least from a provincial standpoint, there are no laws that require a vaccination in general, and so you cannot be forced. I had another question come in from, and I lost the person's name, unfortunately, but the question was whether this person should ask their employer to give them an employment contract saying my duties have changed, but I have never signed anything. So it's a very good question. So in terms of an employment contract, as an employee, it's better not to have an employment contract in place. That's because employment contracts are usually in favor of the employer. So as an employer, you would want to have an employment contract in place. As an employee, you would not, because most of the time in contracts, employers will try to limit your rights and your entitlements as an employee. And the most common example that we see of that is a termination clause. So sometimes an employer will put a termination clause into a contract where they try to limit your termination entitlements. Other things they might try to do is insert a temporary layoff clause, which allows them to lay you off temporarily. Without that clause and without a prior layoff, they wouldn't be allowed. So there's all these different things that employers can try and put into a contract, get an employee to sign it, and then you're stuck with what you've signed. So to answer your question, you shouldn't ask for a contract. You don't want a contract in place. With respect to the second part of your question about your duties changing, it's important to know what the changes are. Because if your duties have changed slightly, then that's not an issue. If they've changed significantly, if you're now carrying out a different role and you don't want to be carrying out that additional role or different role, or you're not okay with the changes to your duties, that's where you may be able to assert a claim of constructive dismissal. Not every change is going to amount to a constructive dismissal, but in situations where your duties are changing drastically, if maybe you've been demoted, if you're being asked to work more hours to carry out these additional duties, there needs to be a real significant change in them. If there is, you don't have to accept that. You can refuse those changes and you can assert that it's a constructive dismissal, which would then give rise to your right to severance pay. So it's a very complex legal issue when we're dealing with constructive dismissals based on duties alone. It's really important that you reach out to an employment lawyer. If you'd like to reach out to me offline or send more information about your situation here through the comment section, I can assess further, or you can just contact us directly. It's important to provide all of the information so that you can get comprehensive legal advice. So you can always email us at help@employmentlawyer.ca. It's on the screen right there. But it's important that you receive advice from an employment lawyer who has all of the information about what your duties were before and what they are now and what those changes are in order to assess whether you have to accept that or not. And of course, as I mentioned before, if you're happy with the changes and you want the changes in place and they're beneficial to you, then there's no issue there. But keep in mind that if you don't act on it almost immediately, there's a very small grace period. And so if you don't act on it immediately or almost immediately, you're deemed to have accepted those changes. So if there's an issue there, if you're not sure about the changes, you need to get legal advice right away so that if there is an issue there, it can be addressed immediately and we can help you behind the scenes so that there's nothing that you do that can prejudice you from a legal perspective for later on. So I have another question here. Again, I'm sorry, I've lost the question. I have the question, but I've lost your name, which is further down the page. But the question is, I am on sick leave, waiting for LTD. I have 2 weeks remaining. When should I resign? Before my LTD or at the end of the sick leave? The answer is, oh, and sorry, I'm just getting a message here. It's from Tess. So Tess, thank you very much for your question. Very good question, and one that we get a lot with respect to, what should I do while I'm on medical leave? One thing with respect to my disability benefits, but it's quite another when you're dealing with an employer. And so the answer, and I cannot emphasize this enough, Tess, is you do not resign at all. You should not be resigning. You don't have to resign. When you're on a medical leave, it's a leave of absence from your employment. You continue to be employed. And then when you are clear to return to work, you're able to go back to work, go back to your same job. So if you have an employer who's trying to pressure you into quitting, you should not do that. And you should get in touch with us right away so we can assist you in dealing with that. But if your employer is not pressuring you and you're just asking the question kind of generally, you don't need to resign. Your employment will be there when you're able to go back to work. You don't have to resign. It does continue while you're on medical leave. You continue to be an employee. And this is regardless of whether you get access to LTD benefits, if you have disability benefits, if you get EI sickness benefits, if you don't get any of those benefits, whatever the case may be, while you are on medical leave, you do not resign, whether that be during your leave or at the end of your leave. At the end of your leave, you return to work and you go back to your exact same position and job as long as it still exists. If it doesn't exist, they have to put you back to the next most similar position. They cannot terminate your employment while you're on medical leave or after your medical leave when you're supposed to return to work. The employer has to accommodate you. They have to hold your job for you while you're gone. And that doesn't mean that they can't replace you while you're gone. They can hire a replacement while they're gone or while you're gone, but they have to have you come back when it comes time for you to come back. So it's really important to us that you do not resign. I see your comment here, Tess, you need to find a new job due to stress. Deal with that at the end of your leave. While you're on medical leave, there's no reason for you to resign. You keep your job, you keep your health benefits as long as you already have health benefits while you're employed. Keep that going. There's no need to resign now. You can deal with it later on. If you are in a situation where the toxicity, if there's toxicity in the workplace, and because there is a toxic workplace, that's what's causing you stress and causing you not to be able to work, that may be a different story where you may be in a situation of a constructive dismissal where your employer has made the workplace so toxic that you can't continue working there. It's a very high threshold to meet from a legal perspective, and most cases, unfortunately, don't necessarily meet that threshold, but it's important to get legal advice so that you can find out if you have the facts to support that situation. And if you do, then it's a different conversation, and there may be something more that can be done now rather than waiting. So I would recommend, Tess, that you get in touch with us so that we can look at your situation a little more closely and see if that's the case. All right, I'm just looking at some other questions here. So I have a question from Gina on YouTube who asks, if you are fired for not getting the vaccine, are you able to collect unemployment? And then a follow-up question, should I wait for the employer to let me go or quit? Do not quit. If you're in a situation where you're not going to be vaccinated, Gina, and your employer is insisting that you are, don't quit, because if you resign or you quit, you're not owed any severance pay at all. As well, if you resign or quit, you're not going to have access to unemployment, to employment insurance benefits through Service Canada. So all you're doing when you resign or quit is ensuring that you don't get severance pay or EI eventually. So don't do that. And if you're in a situation like Gina is, do not resign, do not quit. If your employer wants to terminate your employment, the unfortunate thing is they can do that at any time. So putting the vaccinations aside for a second, if an employer does want to let you go, they can do that for almost any reason, as long as it's not discriminatory, as long as it's not because of your disability or your age or your gender, or your sexual orientation. There's a whole list of different grounds that are protected by the Human Rights Code. But other than those reasons, if an employer simply, doesn't like someone, it's not the right fit, whatever the case may be, they are lawfully allowed to let that person go, but they have to provide the proper amount of notice and or severance pay. And if they don't, that's where we hear the term wrongful dismissal. And so when it comes to applying that to vaccinations, now that we're dealing with all these vaccination policies, as long as you're not getting vaccinated because of medical or religious reasons, the employer can unfortunately let you go for not being vaccinated, but they do have to give you severance pay. So you wait it out, you see if they let you go, and if they do let you go, you come and see us to evaluate your severance package, because the odds are, I'd say 9 times out of 10 or even 10 times out of 10, whatever you're being offered is not enough. So you wait it out and you see if they let you go. They may not, and then you keep working. If they do let you go, then you will receive a severance package, or you should receive a severance package, and then you should get in touch with us so that we can review that for you and let you know where you stand. I see, Gina, as a follow-up, you say, I put in a religious exemption and they denied me because they said my religion was not by natural law. I'm not sure what you mean by that, Gina. If you want to contact us offline, give us more information, that might be helpful. We certainly, it's the law is very clear that if it is actually a religious reason, if your religion, a recognized religion, does not allow vaccinations, then that is something that's protected by law. So I'm not sure exactly what happened in your circumstances. If it's not a recognized religion, that could be why. If it's a political belief rather than a religious belief, or a personal belief rather than a religious belief, again, that's not protected. But as I've mentioned, there are religious exemptions. So do contact us, and we'll be able to address that in more detail. I have a question from YouTube asking if this applies in the US. No, it doesn't. We are in Ontario. I'm a lawyer who's licensed to practice law in Ontario. So all of the advice I'm giving applies to Ontario. Some of it does also apply to other provinces because the law is very similar in Canada, but it does not apply to the US. I have a question from Razor Sharp on YouTube. How can I object to a temporary layoff? I feel like my employer is just waiting me out so that I will quit. So in terms of a temporary layoff, as I touched on before, they are illegal or unlawful unless one of two conditions are met. Either you've been laid off before, in which case there's a precedent that's set where the employer is now allowed to lay you off again, or you've signed something like an employment contract that says you agree that they're allowed to put you on a temporary layoff. So if neither of those conditions exist in your situation, then they're not allowed to put you on a temporary layoff, and it can be a termination of your employment. And so it's really important when dealing with temporary layoffs, which can be constructive dismissals, terminations of employment, because your employer is basically not allowing you to work and cutting all of your pay. It's important to act quickly. So the faster you act, the better. With temporary layoffs specifically, if you don't act right away and you have let several months go by because it's a pandemic and you were hoping that you would be recalled back to work, that's not fatal to your case. It doesn't mean that you can't assert constructive dismissal later on. And so if this is a situation you're in where either it's just happened or it happened a little while ago, but now you're thinking it might just be a situation where, like you said, they're trying to wait you out. They want you to find another job. You are hoping to go back to work. You're not sure what's going to happen. You need to act fast. So it's important to get in touch with us. You can contact me. You can contact our website, employmentlawyer.ca. You can email us at help@employmentlawyer.ca or get my information off of our website and contact me or any of our other lawyers. But you do need to move on this as quickly as possible so that you make sure you're in the strongest legal position possible in terms of objecting to that temporary layoff and making sure that your rights are protected. I have a question here from CM on YouTube who asks, how can one deal with settled bullying at work? So I think the question is asking how to deal with settling bullying at work, resolving bullying at work. And if that's the question, then if you do feel that you are being bullied in the workplace, the first step is to file a complaint internally. So every company has a process that they have in place in terms of filing a bullying or harassment complaint at work. And so the first step is you have to raise it, because if you don't raise it, even if the company is aware of it, they can say they didn't know. And so the first step is raising it, because they have an obligation once they know to investigate and to ensure that they're creating and maintaining a healthy and safe workplace. So the first thing you can do is raise it internally. That then triggers the employer's obligation to investigate. They will investigate, they will come to a conclusion, and they will hopefully put measures in place, as they should, to make sure that the workplace is safe and that you're not being bullied moving forward. If they don't follow those steps, then you can, as a second step in your process, file a complaint with the Ministry of Labor. And once you do that, the Ministry of Labor will assign an investigator. The investigator will look into the situation and they'll determine whether the employer complied with their legal obligations in either investigating, if they did investigate but they didn't investigate properly, where they went wrong, what they would have needed to do. And if the Ministry of Labor finds that the employer did not comply with the law and did not follow their obligations, they can fine them. On top of fining them, which doesn't really do much for you if you're being bullied at work, the Ministry of Labor will make an order to put certain measures in place in order to protect you moving forward. So those are the steps that you have to take. I encourage you, if you are experiencing any type of bullying at work, to make that complaint as soon as possible and get that investigation process going so that you can hopefully be in a much better workplace very soon and have the workplace improved. If that doesn't happen, as I mentioned, you can file a complaint with the Ministry of Labor. You can also contact us if you're having difficulty dealing with it, if you're finding that you can't be at work because the bullying is just so bad that it just rises to that level where you just can't be there. Get in touch with us. We can review the situation for you and let you know where you stand and if there are options that we can assist you with in terms of that process I just mentioned. So I have another question. We're getting to the end of our time here, and I have another question here. I know I haven't gotten to all the questions, but again, if you have a question I didn't get to, please contact us offline. And you can email us at help@employmentlawyer.ca in order to ask your question. But the last question, I'll get to it now, is from David on Facebook, who asks, do you need proof of you got let go due to human rights violations? So what David's asking here is, in terms of a human rights violation, if you think that your employment was terminated, if you were let go because of a human rights ground, protected ground, do you need proof? And the answer is generally yes. It can be, proof or evidence can take many different forms. But in the vast majority of cases, it can't just be implied from the circumstances. So in other words, if you happen to be 75 years old and you were let go, it can't just be that you think you were let go because you are 75 years old. There has to be more evidence than that. And an example I'll give you, which actually happened to a client of mine a couple years ago, is the termination letter actually said, you've reached 75 years old. You are, at the age of retirement. We are letting you go. I'm paraphrasing, but that's basically what the letter said. Now, it's not always as cut and dry and black and white as that, but that's an example of the kind of evidence that shows that there was actually age discrimination happening there. It wasn't just a coincidence that this individual happened to be 75 years old. So it can't be that you happen to fall under a category that's protected by the Human Rights Code. It has to be a little more than that. It has to be that there's either something said or something implied, before your termination or around your termination that indicates that part of the reason for your termination may have been a ground that's protected by the Human Rights Code. And again, just to list some off, that's age, disability, race, sexual orientation, gender, family status. There are, many different grounds that are protected. And if you feel that, they did let you go because of one of those code protected grounds, then certainly that's something to look into further. And on top of severance pay for being let go, there may be an entitlement to human rights damages as well. So if you are in a situation like that, it's important to get advice from an employment lawyer right away. You can contact us and we can let you know, whether that's something where you may not have evidence of it. It might be something that, happened or didn't happen, but it's important to discuss it with an employment lawyer so we can let you know if there is, a good chance of success with that type of argument. Because if you are let go because of one of those code protected grounds, or even part of the reason is one of those grounds, certainly there is a human rights issue there as well. So it's important to act on that because with a human rights issue, you only have a year to pursue it, rather than the 2-year limitation period you'd have for a wrongful dismissal or any other type of civil claim. So that's it for me today, everyone. Unfortunately, I have to end the question and answer session. We're just over 30 minutes here. But again, if we didn't get to your question, visit us at employmentlawyer.ca. You can contact us there. All of our contact information is there. Please feel free to email me directly, and I'd be happy to answer any of the questions that you have that we didn't get to today or that pop up moving forward. So thank you for joining us. Thank you for all of your questions, and we'll see you in the next session.